So Alexis, just unpacking all that is at stake here, tens of millions of borrowers awaiting the outcome of this. What was your reaction to what you heard from today's hearing?
Well, I think it's a little frightening for the Biden administration. Clearly, a fair amount of hostility from the conservative justices, and they are not just the majority, but the supermajority. So, as you've already mentioned, there are two initial issues, or there's an initial issue and then there's a substantive issue, right? The standing question is, are the litigants here in the position to actually bring this lawsuit? That is, have they been harmed by the executive action? And that, I think the Biden administration had a lot of hopes going in that they would have a strong response from the court in their favor, because honestly, the standing here is very questionable under existing precedent. Normally, and especially the conservatives are very reluctant to allow standing. It's you have to actually really have been harmed. And both sets of parties, the states that brought these cases and the two students, there are rather extraordinarily weak standing cases because neither of the two groups has actually can demonstrate any harm. Any harm they allege is purely speculative. And in the case of the states, they're not actually they're bringing this case on behalf, in part, of an entity in Missouri that is not even part of the state, and it decided apparently not to bring the case itself. So it's a third-party standing issue, which is even more tenuous. So there's that. And again, I think the Biden administration thought that they would be on very strong footing because of the weakness of these standing claims. But on the substantive side, I think they were perhaps more worried just because of the trend of this court to declare national programs, regulatory schemes that have been adapted, or promoted by different agencies to raise what is called a major question. This is an entirely new, and some say fabricated, doctrine that has just begun to appear. I think Justice Kagan has it right on the mark. The law is very clear. Those justices who also call themselves textualists should simply look at the law. It could not be more evident that what the president has done is within the four corners of the law by any stretch. And that for them who call themselves textualists now to rely on something called the major questions doctrine to overturn the clear text is about the most activist kind of response to a congressional action.
I'll leave the textual definition to you, but what does a national emergency, COVID in this case, have to do with paying back student loans?
Well, the text itself says that the loans can be modified on the basis of a national emergency. So the fact that
my question
there's a national emergency, the text of the statute allows there to be a modification. I think we all agree that the pandemic and COVID were national emergencies.
Did they impact people's ability to pay back student loans, though? And what's the precedent moving forward if you can wipe off $400 billion because of an emergency that didn't necessarily have any precedent, didn't impact at all their ability to take out or to pay back loans?
So the whole point of the act, which was passed in 2003, was to address the impact on student loan repayments of the massive dislocation and economic harm that happened after 9/11 and the subsequent fallout from the recession and so forth. Well, a very similar thing happened during the pandemic. We had a shutdown of the entire country and the government, and businesses and travel, and people lost their jobs. And so it's an extremely equivalent situation. So it's exactly the type of thing that Congress had in mind when they passed the HEROES Act. Remember, that was right after 9/11. They didn't have that in place right away because nobody had anticipated the terrible terrorist act. But to be ready for the next time there was a national emergency, and they made clear to specify that it was either a military or other national emergency. And this is exactly within that what they were anticipating they might need to be able to respond to.
Yeah, I guess my assumption is, and we'd have to do the math, that 90% of these student loans well predated the coronavirus pandemic. But given where the direction appears to be headed with the conservative makeup of the Supreme Court, where do you think this heads next?
Well, I'm personally not a fan of this newly created, fabricated out of thin air doctrine of major questions. But I think that's where the majority of the court is going to go. I don't think they're standing. I think that the litigants should be ruled out on that basis. But I think that didn't seem likely to happen. And if it doesn't, I think the litigants are going to win because this court seems to want to ignore text in this case and take unto itself the decision of whether this is a major question or not, and write the statute itself rather than having Congress do it.
We will continue to follow the case. Caroline Fredrickson, appreciate you being here. Thanks so much.